Good evening, everyone. I call this meeting to order. Welcome to meeting number 82 of the House of Commons Standing Committee on Industry and Technology. Silence, please. I've called this meeting to order. I know that summer is here and we're all looking forward to leaving, but we still have important work to do. Now, apologies to the witnesses for the delay. Pursuant to the order of reference of Monday, April 17, 2023, we are continuing our study of Bill C-34, an act to amend the Investment Canada Act, and today we are continuing clause-by-clause consideration. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23, 2022. Members are attending in person in the room or remotely using the Zoom application. I would also like to remind members, the directors regarding the use of microphones for the protection of the interpreters. Now we have before us today Mark Shan, Senior Assistant Deputy Minister, Strategy and Innovation Policy Sector. We also have James Burns, Senior Director, and Mehmet Karman, Senior Policy Analyst, Investment Review Branch. At our last meeting, we left off at Clause 14 and CPC 8 was defeated. And so we were at CPC 9. Unless I am mistaken, Mr. Perkins had the floor. I may be wrong, but we are now on CPC 9. Mr. Perkins.
Very much, Mr. Chair, and nice to see the officials back again after talking about the F1 on the weekend. So I'm pleased to move CPC 9, which adds a new section to the bill, and I'll read that. For the purpose of subsection 1, the fact that non-Canadian has previously been prosecuted within or outside of Canada for an offence involving an act of corruption constitutes by itself reasonable grounds. And this is in tangent, this amendment's put forward in tangent with other amendments we've put forward targeting section 25.2.1, 25.3.1, and 25.3.1.1. This amendment seeks to ensure that an automatic, we've had that chat before, the May versus Shell, an automatic national security review is conducted whenever an investment is made by a non-Canadian enterprise that has previously been prosecuted for corruption. So witnesses like James Burton have argued in the committee as a witness that Canadians cannot expect companies that behave atrociously in foreign nations to suddenly operate normally once they arrive in Canada. In fact, on meeting 70, May 1st, 2023, Dr. Burton said in his testimony, in terms of our previous policy of allowing Chinese investor immigrants, for example, to come to Canada, the basis for assessment was whether the Chinese person who wanted to invest in Canada had behaved in a way that maintained the standards of China in how much income tax they evaded and how much bribery they paid, and on the assumption that if they were following the norms of China, they would follow the norms of Canada. The program was eventually canceled because that just didn't work. You can't expect the company to behave morally in Canada when it's been behaving atrociously in foreign nations. That's my opinion, is what he said. And I'll use as an example, and I know I've used it before, but I just want to mention again, Hytera, which in 2019, I believe it was, acquired Norsat in Vancouver, who in 2011 acquired Sinclair Technologies in 2011. And Norsat, or Hytera itself, the parent company, a Chinese state-controlled company ultimately, was convicted in 2022, or I should say charged in 2022, with 21 counts of espionage in the United States, as well as banned by President Biden from doing business and bidding on contracts in the United States. Now, while it wasn't an acquisition per se, 8 months later, both the RCMP and Canadian Border Services Agency procured equipment from Hytera. And in 2019, the Minister of Industry of the day only put forward the first level of security review for that acquisition and said, that's okay, we don't need to go any deeper. Now, I've not seen the details of the deeper reviews on any national security review in quite a while, so the level of detail may have changed, but the purpose of this is twofold. One is to make sure that if they are charged, and I guess the reason is, and I know I've had some discussion with government members about the issue of prosecuted versus convicted, and here's my challenge there. I think I may have said earlier in a little email exchange that I have a problem with if a company has a remediation agreement, that whether or not that's technically a conviction, whether or not a company has found itself in a place where it could do a settlement out of court for whatever reason, and the undisclosed elements of that, those are usually private and undisclosed, would prevent us from having an automatic review for corruption, because if you changed it to say they had to be convicted as opposed to charged, and I've not seen a way to say, other than charged, where you can take account of all of those circumstances in legislation to do it. Doesn't mean that you would, that this would be rejecting any takeover. It's just forcing it through a review. So to me, any time there is a charge on a company, there is a bit of where there's smoke, there's fire. Sometimes there's reasons about how they get off, and that, to me, would mean that that company is perhaps operating with some particularly not savory practices. If they've been charged, they've probably been doing it well beyond what's been charged in other countries, and some companies, even some Canadian companies, have been charged abroad with similar types of issues. Famously, we had the issue of the remediation agreement that Canada was putting in on SNC-Lavalin on the court case, which resulted in the Minister of Justice and Attorney General leaving. So I think Canada has to set a higher standard for the companies that we would allow to operate here in this country, and that by doing this, we also perhaps send a signal to Canadian companies to be a little more careful, not just say that, bribery and conviction in certain parts of the world, bribery and corruption is a part of doing business and how you get contracts, that we aspire to a lot more. We aspire to a higher level of business ethics, and Investment Canada Act does not reflect right now the ability of the minister to do that. It only has net benefit review and national security review as options, and I believe that corruption, bribery, and charges in itself warrant making sure that we take a second look at any company that intends to try and make an acquisition in Canada.
Merci beaucoup, Monsieur Perkins.
Thank you, Mr. Perkins. Mr. Fillmore, followed by Mr. Lemire and Mr. Williams.
Monsieur Fillmore.
Thank you, Chair. Rick and I, Mr. Perkins and I have had several conversations about this matter, and at the end of it, though, our team is much more comfortable with the language of convicted. I would like to go ahead and move the amended language that was distributed last week that replaces prosecuted, I beg your pardon, that replaces charged with convicted. Sorry, that removes prosecuted and replaces it with convicted.
So that's a sub-amendment that is proposed for CPC 9, so to change prosecuted to convicted.
I don't recall, I know you and I exchanged some emails, but I don't recall seeing the clerk sending something out.
I'm not sure. I haven't seen the. One moment. It will be sent around right now to members, but it's a very simple change if you look at the third line of CPC 9, so that a Canadian has previously been convicted instead of prosecuted. So that's a sub-amendment moved by Mr. Fillmore. So on the sub-amendment, Mr. Williams?
Well, I just had a question first through you, Mr. Chair, to Mr. Fillmore. I guess just if you could clarify why. And the second part of that would be, does it include, if it's not convicted, let's say there's a settlement with a company, would that still be included in your definition?
Thanks. So at a high level, it's about, that old canard of innocent until proven guilty. But to go deeper on the detail, I'd invite Mr. Sean to weigh in if that's helpful to you.
Appreciate the question, Mr. Chair. I think convicted would be the technical definition of convicted, which would mean that you'd actually been found by a court to actually be guilty. And so I think it would depend on the specifics of the jurisdiction and how their law is structured as to whether or not that would be, in fact, the case where there may be some form of plea. Often that does actually involve with a guilty trade, in the sense that you agree to the guilt charge in addition for the mitigation factor. So it would depend on the use case and the specifics. Yes.
So I'm going to give one example. Everyone knows Walmart, and Walmart Mexico was involved with a bribery scam for permits for store openings. I guess it was a big scandal in Mexico, but it's a multinational company. They were never convicted. They reached a settlement with the U.S. Department of Justice and Securities Exchange Commission, and they paid substantial fines. So it's an example of one company, and there's tons of them. I'm not going to name all of them, but I think the example was they were not convicted. But certainly as a major company, when we look at the review process from our other allies, so I've been comparing a lot in this committee, CFIUS, and also the United Kingdom, the Investment Security Unit. Both of them will include companies who even were alleged to be in part of bribery in a mandatory review in some part of their process. And Walmart may be a bad example for that because it's going to be other companies that we've talked about at length about a critical strategic list of industries. But if any of those companies, for instance, were not convicted or reached a settlement, the premise would be they could not be involved with a mandatory review, and there's lots of examples where we might need that to be included. So it does not always mean that, I think based on our conversations for the last little while, the review process is only triggered in certain circumstances right now. I think we're less than 2% of reviews. Is that correct?
National security reviews take place in every instance of investment.
In terms of going through the full process, though, there's a really low number that we do right now.
So the full process, by which you mean that they've exhausted the additional avenues available for an extension of the review period, that is correct. That is a relatively small number of investments, but all investments on the merits of the investment are contemplated from a national security perspective.
So I guess I look at the other way then. What is the risk of any company involved with any bribery or corruption for not being reviewed? I think, the innocence, I understand that. We want to have every company innocent until proven guilty. But if almost every company goes through the review process as a whole anyhow, why would we not then just include that as a definite? And the reason, again, I'll go back to the Investment Security Unit, ISU for the UK, CFIUS itself for the Americans, they all include that under part of the process in evaluating an investment security review. They go so far even in the UK to have the National Security Investment Act 2021, and that was legislation that provided a new regime for reviewing and scrutinizing investments on national security grounds, and they requires mandatory notifications for certain types of transactions and companies with corruption or bribery charges. So they've actually named it, and this is part of the United Kingdom's legislation. So again, comparing apples to apples, when we look at some of our Five Eyes, the ones that are doing it, the UK has done it. So, you know, we need to really ensure that I guess the question I have is what's the harm if a company has been named with bribery or any other kind of malicious intent on that sector, or bribery or corruption? What's the harm of having everyone mandatory reviewed if already we're seeing mandatory reviews across the board in many instances? To staff, go ahead.
So, as noted, right now what determines whether or not an investment moves from 25.1 to 25.2 is the information that's developed in the analysis that's provided by the national security agencies. This amendment would automatically make the determination that the information warranted a 25.2 as opposed to allowing the information to make the determination. And the only consideration I would raise for the committee is that this amendment speaks to any jurisdiction and that there are politically motivated both prosecutions and, in a limited number of cases, convictions on the basis of corruption. And so this would be extending to affirm a mandatory 25.2, which is not the same as the mandatory national security review, which will allow the national security agencies to determine whether or not we move from 25.1 to 25.2 to 25.3.
Mr. Chair, just who would make that determination then? Is that the investment review division itself? In terms of if we leave it up to interpretation, a real important question, who makes that determination and if a company is going to go through that review process?
So the national security agencies are consulted, and their advice is sought through the Minister of Public Safety to the Minister of ISED, who makes the determination as to whether or not an investment moves from 25.1 to 25.2.
And what's through you, Mr. Chair, what's the timeline difference if a company goes to 25.2 in terms of report period or delaying that transaction?
Initially, it adds 45 days.
40. So what we're saying here is that if this goes through with a mandatory, no matter what, it's 45 days automatic for every single company?
It's every single company that meets this test would automatically be determined to be sufficiently of consideration on national security grounds to require further analysis and further assessment as to whether or not they meet the next test. But as I said, right now, the decision tree is the information determining the test, which is this a national security concern? Is this injurious to national security? Could this be injurious to national security? Would this be injurious to national security? And it's the analysis of the security agencies that right now prompts those shifts from 25.1 to 25.2 to 25.3 in advice to the minister. This would essentially mandate an additional period and additional analysis on the premise that it already has met that test.
So I guess it comes down to, how the committee feels about corruption and bribery charges in terms of investor review process. There's so many different companies that have been involved with this. So even companies well known like Rolls-Royce Holdings and Breyer SA, Walmart, like I've mentioned, BAE Security Systems. I mean, these guys are operating across Canada. So Siemens AG, which is a German company. So we do have a lot of different companies that are involved in this, and I guess the question would be, what are we trying to protect in this legislation and for the review process, and what kind of pressure are we trying to put on companies that may, in fact, are trying to make a legitimate investment into the country. But I do believe if we're looking at what our other countries are doing, especially the UK and the Americans, they seem to have this included, and I don't know why Canada would have to be a little more lax on that. I would think that Canada would want to be at least on par with our Five Eyes counterparts, and I know that we're looking at a lot of different issues like transparency, and one of my big ones is we need to look at how the investment review division works across multi-agencies, which I think is really important. So I'd certainly leave that to debate here for the committee for the remainder, but I certainly think that we should consider leaving the mandatory in. Thank you.
Just on my list, I have Mr. Viss, Mr. Boulris, Mr. Généreux, Mr. Fillmore, but just as a respectful reminder to members, we are now on the sub-amendment, not on the amendment CPC 9, but the sub-amendment that Mr. Fillmore has proposed to change prosecuted to convicted. And my understanding also is that there is support for this amendment CPC 9 but we're on the sub amendment right now. So if it's not on the sub amendment, we'll get back to the amendment once the sub amendment has been decided upon. So, est-ce que Monsieur Viss voulez?
Mr. Viss, do you want to wait?
Yes, go ahead.
Okay, so just for well, thank you, Mr. Chair, and thank you to our newest members of the committee that will be with us for many months to come. It's great getting to know you guys, and looking forward to many months of deliberation over this bill. The terms convicted and prosecuted are related to the legal process, but they refer to different stages and outcomes of that process. Would that be correct?
That's correct.
Okay, so prosecuted would refer to the action taken by the state to bring criminal charges against a corporation, correct?
Correct.
Okay, so when when a company is prosecuted, it means that they are officially accused of committing a crime and are subject to legal proceedings.
Correct.
Okay. The prosecution prevents evidence and arguments to prove the accused, in this case corporation, beyond a reasonable doubt?
It would depend on the jurisdiction.
Okay, perfect, yeah. And the objective is a conviction. So a conviction, on the other hand, refers to the legal determination of guilt made by a court or a jury?
Depends on the jurisdiction, but
Okay, generally speaking, in legal theory.
generally
Okay.
speaking, yes.
So if a company is convicted, it means that they have been found guilty of a crime by a judge or a jury, either through a trial or a guilty plea.
Would depend on the jurisdiction.
Okay. A conviction typically follows the prosecution's successful presentation of evidence and the defense failure to sufficiently challenge or refute that evidence.
Again, would depend on the jurisdiction.
Okay. Once convicted, the company may face penalties such as imprisonment of certain directors of the company, fines, probation, or other consequences as determined by said law and said jurisdiction.
Depending on the jurisdiction, yeah.
Okay. So in the context of this bill here, I think when we go back to when we wrote this amendment, and now as we discuss the sub-amendment, it really came down to what should a government do to prevent foreign investment from a company with either a poor human rights record, who, and as we have clarified now, has been convicted or prosecuted of a heinous crime in another country. I think when Canadians think about the act that we're discussing today, they want to make sure that our elected representatives and the officials in respective departments have the tools they need to sufficiently protect Canadians from undue harm in the case of business activities. So I think governments in general have a number of ways that they can look at this. One is legal and regulatory measures that we're discussing today. And I think based on our conversation last week with Phil Lawrence, we had a great debate about whether we can have positive or negative, positive lists or positive determinations put into our legislation to ensure that we receive the outcomes that people want. I'm glad the government is willing to work with us on bringing this forward. We also, and this is what I'm scared about through this whole process, and not at you and any of you specifically, but due diligence and screening. And that's where I think Canadians really want us to hone in on what we can do to improve due diligence and screening as it relates to the review of possible investments in Canada. Of course, when other states take seriously egregious actions, we can blacklist them, or we can put up different tariffs. We can seize their assets. The government of Canada holds that right. But when we're looking to see investment flow into our Canada, the due diligence and screening is essential to what people want. And I think a clause like this one, as amended by the government side, really will provide a lot of assurances to Canadians that we're moving in a direction with a more direct law that is clearly understood, can be clearly articulated and that the Canadian people can hold us as elected officials to account to make sure that we get this right. So we're not going to see more cases in Canada and British Columbia where companies are buying up long-term care homes and treating seniors like crap, and which I believe constitutes a crime. I don't think anyone was ever convicted in those situations. So we've got a really big responsibility here to get this right, and I'm glad that we're working towards that level of transparency. Thank you, Mr. Chair.
Thank you, Mr. Viss, for such a clear expose. I'll now turn to Mr. Boulris.
Merci.
Thank you very much, Chair. I think the sub-amendment is a very interesting one and an important one, because in our legal system, you are not guilty until you're proven guilty. And I think it's very important to make that distinction and to be able to say that just because you're prosecuted, whether it's here or abroad, it doesn't necessarily mean that you've been convicted. So we need to be able to trust our legal system. And in Canada, if you are prosecuted, say, for bribery or corruption, there has to be enough evidence to bring you before a court for a trial. Now here we're talking about here or abroad. So let's say you're prosecuted in Russia or in Saudi Arabia or in another country. What happens then? And I'd like to hear Mr. Sean comment on this, because let us say that there are some sort of frivolous proceedings that have been undertaken. Well, under this amendment, it would be a court anywhere in the world. So in all jurisdictions. So it would include the ones that you named, yes.
Merci beaucoup, monsieur.
Thank you very much, Mr. Sean. Thank you, Mr. Boulris. I'll now give the floor to Mr. Fillmore.
Donc, nous sommes toujours sur le sous-amendement.
So we're on the sub-amendment for CP9. Does anyone else wish to speak to the sub-amendment? If not, I will put it to a vote unless there is unanimous agreement on the sub-amendment.
Okay, so we'll put the sub-amendment to a vote. On agreed on division? Vote. Okay, Madame la Greffière, s'il vous plaît.
To the clerk.
Mr. Fillmore.
In favor.
Mr. Sorbera.
Oui, en faveur.
Mr. Cahir.
In favor?
Madame Lapointe.
Oui.
Mr. Van Bynen.
In favor.
Monsieur Generer.
No.
Mr. Perkins.
No.
Mr. Viss. No. Mr. Williams.
No.
Mr. Lemire.
En faveur.
Monsieur Boulris.
Pour.
Merci beaucoup. Donc,
Thank you very much. The sub-amendment is adopted. And that brings us back to CPC 9. Are there any other comments on CPC 9?
comments on CPC 9? Yes. Super.
So now that it's been amended, if I could with the officials, so if you have been, if there has been a remediation agreement, it would not go to an automatic review now. Is that correct? Is a remediation agreement a conviction or not?
Yeah, it depends a little on the jurisdiction. As I noted, I'm familiar with remediation agreement terms in various jurisdictions, some of which require an exchange of a guilty plea held in abeyance until such conditions are met. So it would depend on the specifics of the case.
Merci. Est-ce qu'il y a d'autres commentaires?
Thank you. Any other comments on CPC 9?
Que ce serait possible de mettre l'amendement aux voix, Madame la Greffière?
Can we put the amendment to a vote, please, Madam Clerk? As amendment? The amendment as amended.
In favor.
Mr. Sorbara,
In favor, please.
Mr. Gahir,
In favor?
Madame Lapointe,
Oui.
Mr. Van Bynen,
Yes.
Mr. Genereux,
Oui.
Mr. Perkins,
Yes.
Mr. Viss,
Yes.
Mr. Williams,
Yes.
Monsieur Lemire,
Oui.
et Monsieur Bouleris.
En faveur.
Merci beaucoup. Donc,
Thank you. The amendment CPC 9 as amended is therefore carried.
amended. 14, sorry, 14. Shall clause 14 is amended, carry. Yes, as amended. So moving on to clause 15, are there any amendments? Mr. Perkins.
Thank you, Mr. Chair. I'd like to move CPC 10. I think it's 10. Am I on the right one? So this is the shall and may sort of thing again. In the current form, Bill C-34 doesn't compel the minister to conduct a national security review, as we've talked about before. We believe the automatic trigger that compels a minister to go a little deeper into the security review rather than making it optional would be helpful. I've mentioned before, of course, my poster childs for this being Tanko, Hytera, those ones where the minister of the day, on whatever recommendations he chose, did not go into enough detail, which in my view, or got recommendations presumably, I don't know what the recommendation was, but that it didn't need to go further than that first stage of review. My concern in that case is I just don't see how a state-owned enterprise, a Chinese company being primarily or controlled through the state-owned enterprise, if not through the state-owned enterprise, at least by the 2017 national security law that was passed in China, requiring it to spy and requiring it to steal technology as part of being a good citizen of the Communist Party of China. That somehow these acquisitions didn't get the in-depth review, how a telecommunications company and its assets in Canada could not be considered strategic, which obviously they are in the U.S. And, I know things have evolved since then with perhaps attitudes toward Huawei and Hytera being charged last year, as well as our only, at that time, and still pretty much only lithium-producing mine in Manitoba being so critical to the issue going forward. Hopefully the Ring of Fire and those things will eventually be developed in Canada, that we're not at the point where our only lithium-producing company is being owned by a Chinese state-owned enterprise and everything it mines goes to China. And I think given the emphasis on the EV strategy of the government and of governments of the day and the move to that was probably a little short-sighted to not get a more in-depth strategic look at either the net benefit or in this case the national security review. And perhaps today the view of security might be viewed a little differently than it was in 2017. I'm not sure, but hindsight's always 20/20. But I think the forcing this to go to a deeper dive removes some of that ambiguity and just gives the minister a little more heft around the table for the minister's ultimate decision. And I won't go over the sort of diligence of various ministers that I went over last time and got a few smiles on about. Regardless of government, not all ministers are created equal. I think Mr. Massey called this the Maxime Bernier clause. And I tend to agree with that. At least he didn't leave any, well, maybe he did leave documents around on that too. But I'll leave it there for now and say that I think that this just provides a suspenders and a belt approach, as someone once said a few meetings ago. Thank you.
Merci, Monsieur Perkins.
Thank you, Mr. Perkins. Mr. Caillere, followed by Mr. Viss.
Great. Thank you, Chair. And thank you to my colleague for the amendment. I guess the worry is that there could be cases where the act of imposing interim conditions doesn't reduce the risk actually, and it could actually increase the risk by, for example, disclosing the location of sensitive infrastructure. So I'd like to propose a sub-amendment, and I'm under the impression that it's already been shared. And the sub-amendment is that motion CPC 10, proposing in paragraph C to amend clause 15 of Bill C-34 by replacing line 26 on page 8 by amended replacing review with the following. Review provided that the imposition of interim conditions does not introduce significant new risks of injury to national security. I can read that one more time if you'd like.
Okay, so there's a sub-amendment on the floor, and I believe it's been circulated. I'll make sure that it is sent again, but for everyone's benefit, essentially it's at paragraph C. So if I understood you correctly, Mr. Gair, after review, there would be a comma, provided that the imposition of interim conditions does not introduce significant new risks of injury to national security. And I believe members have received have received and will receive the exact wording of sub-amendment to CPC 10 that MP Gahir is proposing. So we can open the floor on the sub-amendment if there are questions and comments. But
Sure.
yes, but
I'm trying to follow where you're putting it, but
so we'll just wait 1 second. So I understand it's been received by all. Are there any questions? Or comments? Mr. Perkins.
so I'm just trying to read it and compare notes. Is this substituting for my change, or is it? I'm trying to figure out where it goes because.
So it'll go in paragraph C to amend clause 15 by replacing line 26 on page 8.
So does it, because it doesn't say what I've.
I think it's,
I think
if you
I'm
look at
got
your
the wrong-
amendment, it says that could arise during that review. So it'll just continue after review, comma, provided.
Sorry, the one I got is still the corruption one.
Oh.
Unless I'm reading my email wrong here. Oh, here we go. Okay, I got it. Be easier if you had paper copies.
Review and then continuation before the period.
1C, C1. So it's just an addition. Could the officials just explain a little more about the risk that you're trying to?
So, mandating the imposition or deletion of interim conditions, essentially, there are examples, for instance, of a national security case where interim conditions may not be appropriate. So if it's a transaction, for instance, involving the purchase of a business with a location that is sensitive due to its proximity to a sensitive site, if that transaction hasn't closed, there would be no appropriate interim conditions. The only thing that's appropriate in that produce would essentially be the final condition. And there's national security risk during the review if we were actually to have interim conditions disclosed until actually the determination has been made. So this essentially would just ensure that there's a consideration of national security considerations about the interim conditions.
Thank you very much, Mr. Shun. Mr. Perkins?
So I'm just trying to understand, because the principal thing that we're doing in ours is changing may to shall. We're not really changing a lot of the other section that Bill C-34 amends in the Act. So I don't mind, I mean, I'm just trying to understand that this is just an addition, because not that my amendment is proposing a concern, you're just providing a little more clarity?
So your amendment mandates interim conditions, and what we believe that this sub-amendment would do would essentially balance the mandate for interim conditions with, as long as they don't cause injury to national security.
Because it would be public.
Exactly.
That's the issue? Okay.
If there are no more questions or comments or on sub-amendment, the sub-amendment proposed by MP Gaillard, I will put it to a vote unless I have consensus on the sub-amendment. I'm looking around the room. Consensus. We have a consensus. Monsieur Boulris aussi, ça a l'air correct.
Mr. Boulris, you agree? Yes?
Sous-amendement est...
And so the sub-amendment is carried. And that brings us back to CPC 10. Are there any other comments or questions regarding CPC 10?
Okay. Monsieur Viss.
Yeah, we just want to comment briefly through, Mr. Perkins has put forward, and I was so kind of annoyed. I looked at my package and I'm like, what the frick? There's like a million things on may and shall. I just want to clarify for Canadians listening today that shall in legal language is often used to impose a mandatory obligation or requirement. When a law or regulation uses the term shall, it means that the action or condition specified is necessary and must be followed. Failure to comply with the shall provision can result in legal consequences or penalties. It indicates that the specified action is mandatory and binding, whereas may, on the other hand, is used to confer discretionary power or give permission. When a law or regulation uses the term may, it grants an authority or decision maker the option to exercise their judgment or discretion in a particular matter. It indicates that the specified action is permissive, allowing the authority or individual to choose whether or not to act. For example, the minister may grant an exemption in exceptional circumstances. In this case, the minister has the discretionary power to grant an exemption under exceptional circumstances, but it is not mandatory. So for the purposes of Bill C-34, again, Canadians are looking for a stronger bill that will, in some cases, dictate the respective minister takes certain actions and does certain things to provide confidence in our institutions, and in other times to exercise great discretionary power in the national interest of Canada. So that is why we are putting forward these types of amendments. Thank you, Mr. Chair.
Thank you. On that note, shall CPC 10 carry as amended? Yes, around the room. So we're still on clause 15. Are there other amendments? Mr. Perkins.
Thank you, Mr. Chair. CPC 11, which I will make a slight alteration to if I can as I table it. But just to be clear, I believe there's an issue in CPC 11 with clause, what I proposed as a new clause 6.2, if you go to the bottom of that. So I would propose that we put forward this motion without that clause. That has an issue, as I understand it, perhaps around whether or not it would be out of order that it imposes, I believe it is, a new condition or a new requirement on the minister, and that is sort of a minor element of what we're trying to do with this amendment. And this amendment is primarily deals with the fact that C-34, there's no clause in C-34 that allows the minister to review past acquisitions and mergers under national security review process. The amendment seeks to give the minister power to review past acquisitions by non-Canadian state-owned enterprises through the national security review process. The geopolitical situation in the world is constantly changing, as we know. Acquisitions conducted by authoritarian states like China 10 years ago did not pose the same sort of national security threat, in my views, as at that time as they perhaps do now, but could pose a threat today. Several of us have pointed out, and some of the witnesses have pointed out, that the minister needs to have power to review previously approved ICA acquisitions by non-Canadian companies through that. And indeed, I've actually had, a couple sidebar conversations generally with the minister on this, on some acquisitions in the past that say, well, the minister ordered last year 3 mine interests to be divested under policy. There were some other ones that I brought up, like the Tanko mine, and he said it didn't allow him to go far enough back or back far to deal with that issue. And I think, actually, I may have even read the minister referring to the minister, referring to something more recently in the media when he was asked about reviewing an acquisition. So we put this forward because I think whether it's this minister or current ministers, we would need the ability to go back when the geopolitical situation changes, as it has with regard to China. We had, I call it sort of the Bill Clinton policy for many, many years through various governments, that through broader trade and economic engagement in the WTO, we could help China become a more open and maybe not democratic, but more human rights-based country. And I think that actually did work for a while, but the regime changed. And with that regime change, that we've seen, in my view, quite a bit of a step back, and a regime that has very different motivations in how it engages internationally than was hopeful over the last 20 years. And in fact, I think we're in sort of a business Cold War right now, in some ways, with China in particular, which is very aggressive at acquiring around the world mineral rights in our country, companies under certain levels, but also has already acquired some of our strategic assets that we cannot go back on. So, Mr. Chair, I would urge members to at least give the minister the authority to, in the act, at the government's ability to go back and revisit some of these, as many other countries have, I believe, in some of their acts. And I think Britain does. Certainly the United States does. I believe that has some ability of the minister to go back further than ours does.
So, Mr. Perkins, just before anything else, I understand that you moved a sub-amendment to your amendment.
Is that what it's called?
Well, I would think so. It's or is it? No, it's not a sub-amendment to your amendment. Just to be clear, what your amendment is, because everybody's received CPC 11 with 6.2. You're proposing to entirely remove 6.2 from CPC 11.
After my consultations with the
legislative
clerk about
clerks.
that being the part that primarily made it out of order.
Yes, and hence CPC 11 is receivable without C.2. So the debate is on the amendment as proposed and not as written or drafted in the packages that you've received. So on that note, we're moving on. We're debating CPC 11. I recognize Mr. Williams.
Thank you. And just to clarify, Mr. Chair, the original motion minus so we're just debating. Okay. Thank you, sir. And I think to my colleague, the word that we heard on testimony was unwinding, or divestment of transactions. So, and I think I do want to get some comment from the staff. I know that CFIUS uses this. National Security Investment Act uses this. Australia and their Foreign Acquisitions and Takeover Act all have unwind legislation or unwinding of completed transactions. So I just want to get a comment, perhaps starting with the staff, on what they feel about this amendment.
So, as we understand it, the proposal would eliminate ministerial discretion in 25.3.1 to determine whether the threshold for an order to further review certain investments had been met, and also in section 25.3.6 to only allow the minister to recommend a block or divestment for every SOE transaction involving a previous transaction that was already subject to a net benefit review under the ICA. Essentially, the sort of notion of subsequent takeovers has obviously been discussed. And as we noted, those are already subject to national security review. But what this would do is essentially prompt the minister to always go to section 25.3 of the Act and issue an order in the cases where that was the case.
And do you see this as beneficial to unwinding? I mean, so are you saying we have already unwind pieces in the legislation as it stands?
So every transaction is reviewed under national security grounds and has the capacity to be able to block that transaction, if or unwind it if it's a new transaction. Essentially, if it's the first instance of that transaction. So that power already exists, and what this will do is essentially force the transaction to go to the order-making stage at 25.3.
You're not drinking anything more. At least it's on the electronics this time. So in essence, we already have unwind legislation, and so if we determine that a state that already made an investment is something now seen as threatening to our FDI as a whole, the minister already can go and direct the Investment Review Division to now start a new review on a transaction from a decade ago?
No. So what a transaction that is not had a first instance hearing under the Investment Canada Act can be reviewed for national security purposes. An investment that has already been considered by the Investment Canada Act cannot be reconsidered by the Investment Canada Act because the initial decision of the Investment Canada Act is determinative.
And would you see then this amendment allowing that?
Not as we read it, no.
Okay, and I guess I want to get your opinion then on what we are getting, and maybe something that you'd want to see, because it seems to me that the UK, the US, and Australians have that provision in their legislation. It seems that for the United States, for CFIUS, for instance, they have the authority to review and potentially unwind transactions that have already been completed if national security risks are identified. They can initiate, yes, after
first instance.
Yes. They can initiate a review of a completed transaction if it determines the transaction threatens national security. The United Kingdom National Security Investment Act, and this is just from 2021, provides powers to unwind completed transactions. So same thing, correct?
The important distinction here is first instance versus. So I think we're potentially confusing two different concepts. One is, can you unwind a transaction at first instance before your national security or foreign direct investment review? That is capable under the ICA, that's capable under CFIUS, and that's capable under the UK. What CFIUS, the UK, and Canada do not allow is a second hearing under the ICA to come to a different determination. Subsequent transactions, new transactions, transactions that build off of previous transactions, those are all eligible for a further national security review. What is not eligible is to go back to a determination of the ICA if it's already been heard at first instance, and that's true for both CFIUS and the UK regime.
And I think they also have specific conditions, processes, and safeguards associated with it, correct? So,
as do we. So our regime, as noted, if a transaction has closed and has completed, but it is the first instance hearing of the transaction under the Investment Canada Act, we have the capacity to be able to unwind that transaction. What we cannot do is have a hearing have a consideration of an investment under the Investment Canada Act, come to a determination of that investment, and then come back to that investment at a later date and make a secondary determination.
Okay, thank you, Mr. Chair.
See, Mr. Perkins.
Hi, just as a more of a point of interest, the committee members will remember that in the 43rd Parliament, March 2021, this committee issued a report on the Investment Canada Act, responding to the COVID-19 pandemic and facilitating Canada's recovery. And on page 43, it said, since 2009 and as of 2018, and I think this was unanimous, but I wasn't part of the committee then, 2018, 2019, 15 of all national security reviews ordered by the Governor and Council. So there were 15 of 22 resulted by investors whose ultimate control originated from China. Of these 15 investments that underwent a national security review, 9 were either blocked, divested, or withdrawn. So actually going to a more detailed review led to the recommendation 8, which that the Government of Canada introduced legislation amending the Investment Canada Act to allow for the review and the ability to prevent the subsequent takeover by state-owned enterprise of a previous ICA-approved acquisition. of a Canadian firm or assets by a foreign privately owned corporation. So this amendment is meant to try and deal with some of that recommendation that this committee put forward in the Act, and I would urge all members, hopefully, that they some members here, I think, may have participated in the production of that report, but I know that Mr. Massey did, but he's not here today. But that was the intent behind this motion, was to try and implement that provision of the report.
Thank you, Mr. Perkins. Are there any more comments on CPC 11? So, Madame la greffière, je demanderai de...
Madam Clerk, please put CPC 11 to a vote.
Mr. Fillmore,
Against.
Mr. Sorbara,
Against, please.
Mr. Gahir,
Against?
Madame Lapointe,
Contre.
Mr. Van Bynen, Mr. Genereux,
Oui.
Mr. Perkins,
Yes.
Mr. Viss,
Yes.
Mr. Williams,
Oui.
Monsieur Lemire,
Contre.
Monsieur Boulris,
En faveur.
Donc, l'amendement est rejeté.
The amendment is defeated. Now we're still on clause 15. Are there any other amendments? And before we move to any for clause 15,
Members, that the clerk has informed me that we have an extra 15 minutes free. And given that we started late and also that we're not moving very quickly, I must observe, I suggest that we take this free 15 minutes. Merci. Merci, Monsieur Lemire.
thank you, Mr. Lemire, for your support. Are there any other amendments for clause 15?
Monsieur Boulris.
Mr. Boulris. I simply wanted to tell you that it gives me great pleasure to bring NDP 4 forward on clause 15. This is an amendment that was moved by my colleague from Windsor. I'll now let you discuss it.
Merci beaucoup, Monsieur Boulris.
Thank you very much, Mr. Boulris. Now, before we debate this, unfortunately, I have to give you my decision because Bill C-34 amends the Investment Canada Act by including authorizing the Minister of Industry, after consulting the Minister of Public Safety, to impose interim conditions in respect to investments to prevent injury to national security that could arise during the review. Now, under this, it would also provide for the ability for the Minister of Public Safety to end a review. But Amendment NDP 4's purpose is to add a new obligation to the Governor and Council to provide the reasons why an order was not made. And that constitutes a new provision that was not part of the bill as passed by the House of Commons at second reading. And in one of the rules is that an amendment to a bill that has been referred to committee after second reading is out of order if it's beyond scope and principle. And in this case, it is beyond the scope and principle, and therefore NDP 4 is out of order. And as you know, this ruling cannot be debated, but it can be defeated or if you decide to vote on it. Mr. Perkins.
I quite like NDP 4, so as much as I hate to do this, I'd like to do a vote, challenge the chair.
The chair's decision is the chair's decision sustained? Madame la greffière, si on peut.
Madam Clerk, if you could please take a vote.
Mr. Fillmore,
Yes.
Mr. Sorbara,
Yes, please.
Mr. Gahir,
In favor?
Madame Lapointe,
Oui.
Mr. Van Bynen,
Yes.
Monsieur Genereux,
Oui. No, sorry, no.
Mr. Perkins,
No.
Mr. Viss,
No.
Mr. Williams,
No.
Monsieur Lemire,
Oui.
Monsieur Boulris,
Non.
Alors, la décision.
So the chair's ruling is maintained. and therefore NDP 4 is defeated because it is out of order. Are there any other amendments to Clause 15? Mr. Boulris. Thank you, Chair. There is NDP 5 that you have before you, and I would like that to be debated or discussed now, and then potentially move to a vote on NDP 5.
Est-ce qu'il y a des questions?
Are there any comments or questions on NDP 5?
Voyant qu'il n'y en... Monsieur Perkins.
Mr. Perkins.
Ask the officials for a comment on what this would do and not do.
Proposal, Mr. Chair, would include new factors of personal information and the right to use IP for the minister that the minister must consider when determining whether or not to advance a review to Section 25(3), and we would just point members to the current guidelines on the National Security Review of Investments, which clearly indicate that among the factors taken into account in national security reviews are the transfer of sensitive technology or know-how and access to sensitive personal data. The existing guidelines on sensitive technology and IP are actually broader than this amendment and are not limited to whether or not its development was funded by the government, and they're taken into account into our national security reviews.
I looked at this as an addition, that it wasn't narrowing it. Are you telling me it narrows it, further restricts it, or does, to me, it provided a little more certainty by saying that in addition to the powers the minister has, we want a special emphasis or look at things involving privacy and intellectual property.
So we'll come back to the same discussion we had last week about whether or not things are for greater certainty or whether or not they're actually narrow. So, for greater, if there was an indication that this was for greater certainty, it would not negate what precedes, as in already calling and allowing for it. By simply explicitly calling for just these two factors, it draws attention to these two factors and suggests that potentially they were intentional and that no others were. So, as noted, our national security guidelines already include this, are broader than this, and so the question is whether or not this actually potentially draws attention to why they were specifically iterated and not others.
So if I proposed an amendment saying for greater certainty, are those the words that would be needed as opposed to? Or a sub-amendment, I guess.
So in the previous discussion about for greater certainty clauses, it was because there was an itemized list. This is just for the purposes of national security, which is obviously broadly defined, and then we have guidelines that already articulate it. So for greater certainty may actually, we'd have to look at the specific wording to know whether or not it was actually potentially adding greater certainty or whether or not it was actually potentially limiting the national security considerations.
Not being a lawyer, that's why I was suggesting, do the words for greater certainty deal with it as opposed to some other?
Depending on how they're drafted, unfortunately, Mr. Chair.
Merci beaucoup, Monsieur Chan.
Thank you, Mr. Shan. If there are no further comments on NDP 5, what did I say? 15? I meant 5. It's been a long day. NDP 5.
Can I propose a sub-amendment then that just adds?
Je viens de demander.
Well, I have just called the vote, Mr. Perkins, on NDP 5. If there's unanimous consent to go back to allow you to move a sub-amendment, I am open to that.
To the vote. So I'll let you move your sub-amendment, Mr. Perkins, quickly.
Well, and I don't have this written out, so I just wanted to add a new, the words before, it starts in determining whether, to add the words for greater certainty before that.
So everyone's heard the terms of the sub-amendment proposed by Mr. Perkins. Can you repeat, Mr. Perkins? The legislative clerks are asking for greater
Sure.
certainty. Can you repeat?
In NDP, is it 5? that it's brackets 1.01, and the start would be for greater certainty, comma, and then it would continue on as the way it is written.
So everyone's heard the terms of the sub-amendment proposed by Mr. Perkins, and if there are no, Mr. Viss.
I'll speak to the sub-amendment. I wish Mr. Massey was here today. I think this is a really important amendment when you think of businesses like TikTok, for example, coming into Canada and using Canadians' information. I wish he was here to speak to it, frankly, because he knows the subject pretty well, and we would have been better informed. But that's not the case today. I think as we're going to be debating in the fall and examining very closely, Canadians are very concerned about protecting their personal property. This sub-amendment, along with the subsequent amendment, will go a long way in ensuring that foreign companies protect the rights and privileges of Canadians and don't use their information in a negative way. I'm concerned, especially in the realms of social media and companies already operating in Canada, that we don't have more provisions in place already to ensure that we have the information we need. With that, my comments are done.
Merci, Monsieur Viss.
Thank you, Mr. Viss. If there are no other comments, I will put the sub-amendment from Mr. Perkins to a vote.
Donc, est-ce que le sous-amendement de Monsieur Perkins est adopté, Madame la
Madam Clerk.
Mr. Fillmore,
Opposed.
Mr. Sorbara,
Nay.
Mr. Gahir,
Against?
Madame Lapointe,
No.
Mr. Van Bynen,
No.
Monsieur Généreux,
Oui.
Mr. Perkins,
Yes?
Mr. Viss,
Yes.
Mr. Williams,
Yes.
Monsieur Lemire,
Contre.
Monsieur Bouleris,
Pour.
Donc, le sous-amendement est...
The sub-amendment is defeated. So we will now go back to where we were. That is to say we are voting on NDP 5 as moved. Mr. Perkins.
About it. Nothing to say.
we were starting the roll call on NDP 5. I believe we had ended debate, so will Madam Clerk, shall NDP 5 carry? And if you can start, Madam
Mr. Fillmore,
Contre.
Mr. Sorbara, Mr. Gahir,
Against?
Madame Lapointe,
No.
Mr. Van Bynen,
No.
Monsieur Généreux,
Oui.
Mr. Perkins,
Yes?
Mr. Viss,
Yes.
Mr. Williams,
Yes.
Monsieur Lemire,
Contre.
Mr. Bouleris,
Pour.
Donc, l'amendement
NDP 15 is defeated. And that brings us back to Clause 15.
making that mistake, NDP 5, but Clause 15. So NDP 5 is rejected. We're now on to Clause 15. Shall clause, there's no, you have an amendment on Clause 15, Mr. Perkins? Yes.
Yeah, and I think the clerk has copies of it if she could do it. And when I was reviewing the amendments we had submitted last week, there was one area of testimony that I was concerned about that we hadn't addressed, and I think we have discussion. A lot of it came from Mr. Balsillie and a few others, which is the area of intangible assets. So I would propose the amendments being circulated now that Bill C-34 in Clause 15 be amended by adding, after line 18 on page 8, the following, quotes 1.01, in determining whether to make an order under subsection 1, the minister shall have regard to whether the non-Canadian could, as a result of the investment, have the right to intellectual property. I'm sorry, I'm reading the wrong amendment, aren't I? I think I'm reading the wrong. Am I? I'm on the right. Okay. right to use the intellectual property whose development has been funded in whole or in part by the Government of Canada. No, that's NDP. Sorry, that's the wrong one, I think.
Just to be clear, Mr. Perkins, is it the amendment referenced 125-24557? Yeah, I think that's the
I
one.
read the wrong one, sorry.
No,
751?
I believe you were reading the right one. 125-24557.
As it is, the primary purpose of that, as we heard, and it follows up on recommendation 6 from the report I referred to earlier, which said that the Government of Canada encourage Canadian entities to keep ownership of intangible assets developed with federal funds, including intellectual property, by requiring, when appropriate, that they return monies they receive from federal programs or subsidies in full and part. So it arises from the testimony and the committee report on this that said that the minister should have more power to deal with intangible asset sales.
Thank you very much, Mr. Perkins. So just to make sure and be clear, the amendment is the one referenced 125-24557. Are there any comments or questions? If there are none, Madame la Greffière, si c'est possible de placer.
Madam Clerk, could you please put Mr. Perkins' amendment to Clause 15 to a vote?
Opposed.
Mr. Sorbara,
Opposed, please.
Mr. Gahir,
Against.
Madame Lapointe,
No.
Mr. Van Bynen,
No.
Monsieur Geneveux,
Wait.
Mr. Perkins,
Sorry, yes.
Mr. Viss,
Yes.
Mr. Williams,
Yes.
Monsieur Lemire,
Contre.
Mr. Bouleris,
Contre.
Donc l'amendement est rejeté.
The amendment is defeated. Are there any other amendments for Clause 15?
Amendments to Clause 15. Shall Clause 15 carry? Yes? Is it? As amended? Yeah. Yes. Thank you. Are there any amendments to Clause 16? Mr. Perkins.
I think being given this one, sorry. I would like to it's the one that's 125255376 to Clause 16, that Bill C-34 in Clause 16 be amended by adding, after line 28 on page 10, the following. 2, Section 24.4 of the Act be amended by adding the following: subsection 1.1, so it's a new subsection. If the investment would give the non-Canadian the right to use intellectual property whose development has been funded in whole or in part by the Government of Canada in order to make under subsection 1, may require any person or entity from whom or which the Canadian business or entity referred to in paragraph 25(1)(c) is being or has been acquired to repay all or part of such funding. So again, coming from the same report from the Industry Committee in the last Parliament that called on the government to look at any IP related to an acquisition that is being sold, to say if that's been done, it's going to a foreign entity, that the taxpayer money that may have gone into that through a granting council or any other various mechanisms, that if that IP is leaving the country, that IP should actually be repaid. So with that, and I know the officials have just gotten it, if they want to take a look at it.
In any event, Mr. Perkins, we're out of time, so we'll keep in mind that when we resume, we will be at Clause 16 with your amendment from the floor being debated. And colleagues, just to be transparent, given that we've lost a bit of time today and that we are moving very slowly, I'll seek additional resources for after Wednesday's meeting and see how it goes at Wednesday's meeting. If we make good progress or not, then we'll have some extra time to work on this important bill for Canadians. I'm sure you will all agree that's a priority. Et sur ce, merci.
Thank you to our friends of the committee who will be with us again next week, and We can hope, or rather this Wednesday. Thank you to all the support staff, to the analysts, the clerk, and the interpreters. The meeting is adjourned.